On Monday, April 29th, Massachusetts versus Karen Reed kicked off with opening statements as well as the start of the Commonwealth of Massachusetts case in chief. If you're not familiar with this hot button case, linked in the description below is my primer video on the background of this case. Otherwise, if you've already been following it, you might be anticipating the beginning of the case like so many other people. Looking at day one at the end of the day, I think that all in all, it was a much better day for the defense than it was for the prosecution. The defense looked to me like they really came out swinging with their opening statement, and the prosecution, to be honest, kind of fumbled the ball early on, in my opinion. Now, to be clear, going into this case, I've been very much on the fence based on what I researched into the allegations and the various factual pieces in the case. I do fully expect to be on one side or another by the time we reach closing arguments, but I will always do my best to maintain an open door for either side to make a case and to keep an open mind to facts that can change my opinion of what should be the outcome. So going into it, I don't have any particular angle, but I'm going to tell you when certain things are more or less convincing to me or that I find are more or less helpful to one side or another. So with that, let's get into it. Okay, so like I said, day one started out with opening statements as any trial does. The Commonwealth of Massachusetts, also known as the state, also known as the prosecution, went first, as is typical since they're the ones that have the burden of proving Karen Reed's guilt beyond reasonable doubt. Now, before I get into some of the details of the opening statements that happened today, let me first go over what we should generally look for or expect in opening statements in general. Really, the purpose of an opening statement is not to make an argument. That's saved for the end of trial for closing arguments when the two sides argue from the evidence that's already been admitted at trial. The purpose of the opening statement, rather, is to basically introduce the jury to the case. This starts first and foremost with goal number one, which is to create a roadmap for what each side says the jury will see. This basically tells the jury what kind of witnesses they expect to testify, what kind of communications they'll be able to see, what kinds of physical evidence there might be, what kind of surveillance footage, forensic data, bodily injuries, etc. This sets a series of expectations for the jury, and at the end, they will be able to make some conclusions as to whether or not those expectations were met by either side. And then there's goal number two. You see, in a trial, the story generally unfolds for the jury in a piecemeal fashion, and often out of order, since it comes in the form of testimony by witnesses and various kinds of other evidence. And because of that, this can get confusing fairly quickly for a group of people who are otherwise unfamiliar with the details of this story. And this is especially true where the case involves a lot of complex details that twist and turn and get thrown upside down based on who's talking about these details. So really, the human brain can only do so much when inundated with a ton of detailed information. And when the trial is expected to last for weeks and weeks, in this case 6 to 8 weeks, it's even more important to give the jury essentially a system for organizing and understanding and ultimately retaining all of that information. Otherwise, none of it sticks. So basically, that's goal number two, is giving the jury a framework with which to understand and organize and retain all of these details that are going to be thrown at them. Each side, generally speaking, wants to give the jury a framework that is more beneficial to their side. Makes sense. In other words, they want to frame this universe of facts so that when certain details pop up in the trial, the jury maybe takes notice and is able to weigh the importance of that information. One side might want the jury to essentially ignore some facts but focus on others. The other side might want exactly the opposite. This is why establishing a framework for the universe of facts is so important from the beginning, because it gives the jury a guide for what facts are important to pay attention to and what facts they can kind of gloss over and forget. Because remember, it's impossible to remember everything. The human brain simply can't do it. Okay, so that's goal number two. Goal number 3 is to establish a theme for the jury that can get repeated throughout trial. This theme is something that helps to support that side's overall argument. And the way to establish a theme is often by setting up some memorable buzzwords, for example. These are words that might get repeated or echoed with synonyms in the opening statement. And then as that side examines witnesses, both on direct and on cross-examination, they might draw out those buzzwords or synonyms of those buzzwords or that theme from the witness. By doing this, they create repetition for the jury, and repetition helps the human brain remember things. Doing this reminds the jury of that side's framework, their lens through which they want the jury to make sense of the information in this case. And it helps to establish for the jury that that side is actually making good on the promises that they made in their opening statement, that they promised that they would see certain evidence, and they are in fact seeing that evidence. And on top of that, it is actually supporting that side's case. Okay. So in a nutshell, that's basically what to expect from opening statements. So what happened in opening statements on day 1 of this trial? Let's start with the prosecution. The Commonwealth's opening statement was given by Assistant District Attorney Adam Lally. The summed up version here is that, I'm sorry to say it, but in my opinion, the prosecution failed to meet most of the general objectives of an opening statement. I would honestly characterize their opening statement as basically a dry recitation of all the facts and details in the prosecution's case. I suppose you could say that this is giving the jury a roadmap for what to expect next at trial. But the purpose of a roadmap isn't to give all of the details up front. It's to give a condensed version of what they'll see. You don't want to give them the nitty-gritty details all up front. This is where you give them the bird's eye view of the case so that they can see the full landscape of what they're going to be examining. Remember, this is a group of people that are generally unfamiliar with this case and at the very least unfamiliar with the details in the case. So when starting out fresh, they have not been mentally prepared to handle getting inundated with details about dates, names, titles, times, because they simply don't know about who these people are and what they're supposed to be focusing on. It's simply too overwhelming for a new listener to have to try to pay attention to so much minutia at the very beginning. So in terms of framework, honestly, I got nothing from what the prosecution's framework is or is supposed to be. What I got from the prosecution's opening statement was that Karen Reed drank a lot one night, drove her car, and ended up hitting her boyfriend and driving away, leaving him to die in the snow. And there was a lot of detail that went into all of that, but there was so much that was really hard to pay attention to. And there was nothing about what events or pieces of information the jury should be focusing on to understand and accept the prosecution's ultimate argument. It kind of was just word vomit, and even worse, in a monotone speech pattern that didn't highlight with body language or vocal inflections what was important. And in a case where someone has died and so much interest is paid to this case because there are aspects of it that are relatively salacious in nature, it's kind of a feat to make the story of that case boring. So in other words, there was so much detail in the opening statement that it was, in my opinion, basically impossible for the jury to actually focus on any of those details. And while I can't see the jury and I'm not there in the courtroom, I just can't see any of that information really sticking in the minds of the jurors. If this opening statement had been presented to colleagues as basically a briefing on the facts of the case to get someone caught up on the case so that they can start working with Adam Lally on this particular case to prepare it for trial, I could see it being relatively successful for that purpose, because it doesn't require any sort of like emotional overture or any sort of convincing as to why the listener should care about the case. But in terms of an opening statement where all of those things need to be present in order for the jury to actively pay attention and to actually retain the information in this case, I really do think that this opening statement failed fairly miserably, to be honest. And in a case that is this complex and this thorny with details and this contested quite emotionally and quite strongly between both sides, that really is a bad start for the prosecution, who once again, has the burden in this case. Okay, so then how did the defense do in their opening statement? Look, I'm just going to say it. In every way that the state failed to meet the objectives of an opening statement, the defense basically knocked it out of the park. This opening statement was delivered by David Yannetti, one of the two lead attorneys on this case. If the jury was asleep at the very end of ADA Lally opening statement, Yannetti woke them up right at the beginning with the very first sentence in his opening.
Karen Reed was framed. Her car never struck John O'Keefe. She did not cause his death. And that means that somebody else did. You will learn that it was no accident that John O'Keefe was found dead on the front lawn of 34 Fairview Road in Canton on January 29th of 2022. You will learn that at that address lived a well-known and well-connected law enforcement family in Canton, the Alberts. Because the Alberts were involved, and because they had close connections to the investigators in this case, Karen Reed was framed for a murder she did not commit.
He used his voice to deliver an impassioned and emotional opening statement that told the jury that Karen Reed is just another victim in this case and that the bad guy here really is the lead investigator. Yannetti gave a great roadmap that highlighted some of the defense's key points that they'll be unwrapping for the jury. This included Jennifer McCabe's wild Google search at 2:27 a.m. that was something along the lines of how long to die in the cold, and which, by the way, he said she later deleted. Then there's the injuries on John O'Keefe's body and how they allegedly didn't match up with getting hit by a car, but they did match up with, among other things, getting attacked by a dog that, in this case, actually did exist and was promptly rehomed from the family she had been living with for 7 years. And this also included a very, very crucial point for the defense, and one that I think was very poignantly made in the defense's opening statement. That was communications that the defense referenced that were sent between Trooper Proctor, the lead investigator in this case, and other people that showed that not only did he have a reason to cover for the homeowners where all of this went down, because they're very close friends. In fact, they're considered like a second family to him, but also that he was, in fact, ensuring that nothing would happen to them, not because they hadn't done anything wrong, but because they're cops too, quote unquote.
Well, you will learn that on the very day that John O'Keefe was found dead on Brian Albert's lawn, Michael Proctor was texting with his high school buddies about this supposedly secret investigation using his personal cell phone. He was revealing information about this investigation to his friends, assuming that nobody would ever find out what he was doing and what he was saying. And he was revealing his true thoughts about Karen Reed to his friends. Not what he put in his sanitized police reports, his true feelings. To his friends whom he trusted, and in text messages that he never thought would come into the hands of the defense in this case. Lead investigator Trooper Michael Proctor, right from the start, called Karen Reed names you would reserve only for your worst enemies. He told his friends that he hoped that she would kill herself. He told his friends that he had seized her cell phone. And you will learn that he knew he shouldn't have been accessing any content on her cell phone because he knew there would likely be attorney-client communications on between Karen and me at that time. He knew that he was supposed to wait for a search warrant or other permission from a judge in order to go through that phone. But you'll learn that he went through the phone anyway, without permission. And you'll know that he did because he told his high school buddies that he was searching her phone for nude photos of Karen Reed. And he was disappointed he hadn't found any yet. That is the professional and unbiased investigator who was chosen to lead the investigation into the death of John O'Keefe. You'll learn that one of Michael Proctor's high school friends commented to him that with a dead body on the front lawn, the homeowner in this case is surely going to catch a lot of grief. And do you know what Michael Proctor's response to that was? One word. Nope. And he explained why. Michael Proctor assured his buddies that the homeowner would not catch a lot of grief because, quote, the homeowner's a Boston cop too, end quote.
In other words, in communications, according to the opening statement, Trooper Proctor didn't think that he would ever have any of this come to light. And it sounds like he's covering for people because cops get special protection and special treatment. This, to me, was a very powerful start for the defense. Not only does this establish some very eyebrow-raising points that help the defense, but it also casts a very long shadow on the state's entire investigation if the lead investigator is making these kinds of private communications that differ from the way that he's talking about this case publicly and officially. Now, some might look at this and say the defense is just poisoning the well by making the jury mistrust the evidence that the state puts in front of them. And they might say that's dirty. Well, the thing is, the state really should have been able to predict that the defense would have come out this way. The defense team has not exactly made it a secret what they're planning to argue at this trial. They've been banging on that drum to the public for months and months and months. And because of that, the prosecution really should have positioned their opening statement to get ahead of these arguments and to basically tell the jury, these guys are just conspiracy theorists. They have every reason in the world to confuse you guys with crazy talk. But I didn't see any kind of positioning like that by the state here. And so the way I see it, the only framework that's been concretely established is that of the defense. And in my opinion, at the end of the day, that's fair game. So now with all of that said, does this mean that the Commonwealth's case is dead in the water? No. We are at the very beginning of this trial. There is so much trial left. And at the end of the day, the evidence itself will determine which way the jury really goes. I've seen cases where the prosecution completely bungles their opening statement in ways that are actually very similar to this and still ends up securing a conviction. At the end of the day, it really comes down to the evidence and how the jury perceives and understands it. But I would be lying to you if I said that I didn't think that the state now has an uphill battle for this trial based on this early performance. Okay. So now that's the opening statement. On day one, the Commonwealth also put on their first 3 witnesses. The first one was Paul O'Keefe, the victim's brother. The purpose of his testimony was basically to give the jury an emotional anchor for this case. It's very typical for the first witness or 2 to be family members of the victim, particularly where that victim is deceased. This gives the jury an understanding of the very real consequences and stakes of their decision in this case, and it helps them to take it seriously from a very early stage. It also helps to humanize the victim, and it gives the jury an understanding of who they were as a human being. So in this case, we learned that John O'Keefe had been a police officer with the Boston Police Department for 16 years. And we also learned that he had already known tragedy in his life before the night of his death. In prior years, his sister died of cancer just 5 months after her initial diagnosis. 2 months later, his sister's husband died, leaving their 2 children, John O'Keefe's niece and nephew, orphaned. And we learned that in the wake of this tragedy, John took in the 2 kids and became their legal guardian. We also learned that John and Karen had previously dated and that in March 2020, they rekindled and started dating again. Now, according to Paul O'Keefe, they had some arguments over the course of their relationship. And this point led to testimony about New Year's, where Paul was in Aruba with his wife, Erin, and with her side of the family, mostly to celebrate her mom's birthday. At the same time that they were there in Aruba, John and Karen were apparently on the opposite side of the island. And this seems to be an important point for the prosecution, along with the fact that they were there with a big group of people and organized by John's friend, Laura Sullivan. Anyway, the last time Paul said that he had heard from John, he said they had plans to get together on January 29th, but that due to a winter storm, they decided to waive off. On the morning of January 29th, however, Paul said that he got a call from his mother, who said something terrible had happened to John. Paul and his parents then met at the hospital to see him, where he saw Karen, who was totally hysterical in the hallway. She apparently had to be restrained by the hospital employees, and she was screaming down the hallway to the O'Keefe family, asking if John was okay. After all of this, Paul said that they all met up at John's house afterwards for a short while. This included Karen, who arrived with her dad and whose brother and sister-in-law also briefly showed up afterwards. Now, I think the main point that the prosecution wanted to come out of Paul was what came out around here. Paul testified that he started shoveling snow in the driveway because it was snowing pretty heavily all day that day. And at some point he said that he managed to get a hold of a snowblower to clear the driveway a little bit more efficiently. And ADA Lally asked Paul if he found anything in the driveway while he was clearing away snow. See, what the state was teeing up here is an attack on the defense's theory about Karen's right rear taillight. You see, the state says that she damaged her taillight when she backed up over John, killing him. But the defense says that she never hit John and that she actually cracked her taillight instead by backing into John's parked car in his driveway later that morning when she decided to go out looking for him when she realized she hadn't made it home. Now, the state says that they found pieces of her taillight multiple times over multiple days in front of 34 Fairview, where John's body was found. This would suggest that this is where her taillight got damaged. And so here, the state was looking for Paul to testify that he didn't find any pieces of taillight in the driveway of John's home. To emphasize, this is to cast doubt on the defense's theory that Karen cracked her taillight in the driveway where Paul was shoveling snow the next day. Now, there are reasons why I think this on its own isn't an ironclad rebuttal of the defense's argument, but it's nevertheless a piece that the state can definitely use for their side. Oh, and Paul did in fact confirm that he found nothing in the driveway. Anyway, next was Paul's wife, Erin O'Keefe. Now, most of her testimony basically mirrored Paul's. She confirmed how he was awoken on the morning of January 29th by a phone call from his mother, and she went over again the whole backstory of how John ended up taking care of his niece and nephew. But the one piece of testimony that was interesting and different coming from Erin was a conversation that she had had with Karen while they were all in Aruba. This was apparently over text message, but interestingly, those text messages were not introduced through Erin. Maybe we'll see them through another witness, for example, a forensic technician who extracted these texts from either Karen's or Erin's phones. But anyway, these texts apparently described an incident that happened between Karen and John while they were in Aruba. You see, Karen was apparently super upset with John because she said in these text messages, I guess, that she had caught him kissing the sister of his friend Laura Sullivan, the lady that had organized this whole trip. So understandably, this resulted in heated emotions and argument. And this definitely fits into the state's theory that Karen's and John's relationship was really on the rocks and about to end on the night that John died. And this could lead the jury to think that Karen killed John in the heat of the moment, basically in like a drunken rage. And I'll admit, this would be good reason for them to be on the verge of breaking up. But at the same time, though, Erin O'Keefe also testified that Karen and John would get into arguments that she basically characterized on the whole as typical arguments that normal couples would get into. So maybe they weren't on the rocks. Maybe this kissing incident happened, maybe it didn't happen. Maybe if it did happen, they decided to work things out. That is all unclear. But those are points for the state. Now, do they move the needle for me personally in favor of the state? Not really. This testimony from these first two witnesses is potentially helpful to act as essentially a tiebreaker later on down the line. But at this point, I didn't think that either Paul's or Erin's testimony was all that helpful to the state in proving Karen's guilt. Okay, so that's the first two witnesses. The third witness was Officer Stephen Saraf from the Canton Police Department. He was one of the first police officers to respond to the 911 call that there was a man found out in the cold who was unresponsive. In his direct examination, they went through some photos of the front lawn, as well as the dash cam footage from Officer Saraf's arrival to the scene. And by the end of his direct examination, to be honest, there wasn't anything that really stuck out to me that is helping to prove Karen's guilt. The dash cam footage showed her pacing around frantically while police responded to the scene. And Officer Saraf testified that in terms of the snow, he estimated that John was lying on about 6 inches of snow and that he had a light dusting of snow on his chest. To me, this doesn't really look great for the state. It looks, if anything, pretty good for the defense. You see, one of the biggest disputes is when John's body landed where it was found outside the home at 34 Fairview. The state wants the jury to believe that it was around 12:30 a.m. that he landed there when Karen dropped him off, ran him over, and then hit him home. But the defense wants the jury to believe that it was actually much later, after John had gone inside the house to spend time with all of the other partygoers, where they say that he actually died. So establishing the timing of his ultimate placement outside there is very important to this case. And given that the previous 2 witnesses had testified that it had started snowing the night before around 10:30 or 11 p.m., the night of January 28th, how much snow was actually under John and over John's body can actually help the jury to determine how long he had been out there when the police ultimately arrived. So to me, at this stage, it sounds better for the defense if there's more snow under John than on top of John, because it suggests that he had recently ended up in that spot. Now, some people did point out to me as a counterpoint to that Officer Saraf also testified that when he got there, people, I believe primarily Karen, had been attempting CPR to revive John. So this could mean that there was snow on top of John's body that got cleared away in the process of those revival attempts. Absolutely, I agree that that is a very plausible explanation. And the question then becomes, what's the comparison between the snow level under John and the snow levels of the front yard, say a foot or 2 away from John, in an area that was undisturbed by these attempts to revive him? That would seem to be a reliable way to contextualize his body's placement in relation to the snow levels around him for the purposes of establishing that timeline. I honestly don't know the answer to that question, so I'm really hoping that we get more information about that kind of helps to answer those questions. And I will say, it is notable that the state did not highlight the fact about the CPR attempts in that moment, the moment when Officer Saraf mentioned the light dusting on top of John's chest. So the jury may or may not make that connection on their own to benefit the state. I certainly didn't, but I don't know. We'll see. So day 1 ended with Officer Saraf finishing his direct examination. Day 2 picks up with the defense starting his cross-examination. And so far, the defense has chosen not to cross-examine the first 2 witnesses, which is smart in my opinion. These were 2 very sympathetic witnesses with very emotional testimony, and so there's really a lot more risk in cross-examining a witness like that. So to go ahead and proceed with cross-examining either of those 2 witnesses, there really has to be something important in their testimony that you need to draw out. But instead, by choosing not to cross-examine them, the defense does actually a couple things. First, it communicates confidence and strength in the defense's position despite the testimony that was introduced for the state. It basically says this testimony wasn't damaging to us, so we don't need to attack it. And it also says we're not going to be a-holes and attack the family members of the victim in this case. In fact, we're on the same side. They're not our enemy. The investigators here are our enemy. So anyway, all of that means that we don't quite know yet what the defense's cross-examination style is going to be like. But we do know that they definitely intend to cross-examine Officer Saraf, which is what I would have expected anyway. And because cross-examination is really where the testimony gets tested for its credibility and reliability, I am so looking forward to seeing it on day 2. But that's what I've got for day 1. What do you think? Did you watch the trial stream from day 1? Was there anything that you think that I maybe skipped over or missed that you think was important for inclusion in this recap? Let us know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more coverage of the Karen Read trial, join us by hitting the subscribe button and the notification bell so you can find out when the next one is uploaded or when we're going live next. we are streaming this trial from gavel to gavel every single day until the end for the next 6 to 8 weeks. So you can join us for day 2 and beyond. See you in the next one.